court's involvement. I mean, no matter what, if someone's awaiting trial, they should be able to talk to their lawyers.
That's
in a private
crazy,
room,
bro.
every single lawyer. They shouldn't have to talk in a room with a
He gotta talk and he can't even talk in a private room with his lawyers, bro. You know how, bro, what? No, he feel violated right now, cuz. Fuck going on with you, man. I had to, like, test, you know what I'm saying? I had to restart my whole computer and make sure this shit was right. Testing the video like 3 times and shit. Make sure, you know what I'm saying, everything smooth, everything good, cause we about to bring this shit in. You got YNW Melly, man. He fighting for his life right now. It's been over 2,000 plus days, man. I don't know what the fuck going on. What the hell is going on, bro? But we finna figure this out. We finna get into it.
YNW Melly's team filed a petitioner's memorandum of law addressing issues raised at status conference. This is yet another document arguing how Melly's constitutional rights are being violated. Remember how BSO said they should have did this through state remedies? Melly's lawyer argues that state remedies are pointless because he's not convicted yet. You'll see, hit subscribe, here we go. Alright, we got United States District Court, Jamell vs. Gregory Tony. Petitioner's memorandum of law addressing issues raised at status conference. Petitioner sought statutory habeas corpus relief pursuant 28 U.S.C. section 2241. He's not challenging the lawfulness of any state court adjudication. He's not challenging any conditions of his bond because he has no bond while awaiting trial. He has not been adjudicated. Instead, he is objecting to the constitutionality of being held incommunicado and deprived of all meaningful access to his trial counsel while he awaits his state court trial. He was denied relief by his Florida trial court judge, has no ability to seek review of that ruling to an appellate court until he's convicted, and meanwhile suffers severe constitutional deprivation every day without any meaningful remedy in the absence of this court's involvement. I mean, no matter what, if someone's awaiting trial, they should be able to talk to their lawyers.
That's
in a private
crazy,
room,
bro.
every single lawyer. They shouldn't have to talk in a room with a
He gotta talk and he can't even talk in a private room with his lawyers, bro. You know how, bro, what? No, he feel violated right now, cuz.
glass in between them. And if you're scared about the lawyer bringing in something, just pat him down and search him after, if that's what you're really scared about. I don't see the issue. The facts are undisputed and have been stipulated at this point that the petitioner is not allowed to call his lawyers, depriving him of not only constitutional entitlements, but to the same access as every other pretrial detainee in Broward County Jail. In a situation facing the death penalty, the state is arranged to deny him needing access. The state is arranged to deny him needed access to counsel by prohibiting phone calls with his lawyer. He's in perpetual isolation with no outside contact and has not even been allowed a telephone call with his mother. Be so clear that absent intervention by this court, their position is that the petitioner will never be allowed to communicate with his lawyers by phone, have any personal contact with his chosen lead counsel while at jail, leave solitary confinement, or have any phone contact with any family member. And he's not.
Bro, what the what they want the man to do? Talk to the wall, cuz? They want nigga talk to the wall, bro. Damn, fam.
Not even allowed to telephone undersigned counsel
He can't call his lawyers. He can't talk to family, bro. Like, at this point.
during these federal proceedings. I can't believe what I'm reading is real. He can't talk to his lawyers.
What I'm saying,
Something has
bro.
to change with this. They got to let him talk to his lawyers somehow. I don't know what they can do, but I know you're scared of him fucking with witnesses. That's the issue. But at this point, you're straight up violating his right. Petitioner's not appealing from a state court or other judicial ruling and is not asking the court to interfere in or do anything to delay his state trial. Rather, he only invokes this court's constitutional authority to cure a blatant breach of his right to counsel while he prepares for a trial that implicates whether he will live or die. I mean, that statement right there. Whether he will live or die. They're seeking the death penalty, and he's not allowed to talk to his lawyers. How is this allowed in the United States?
What the fuck is going on,
I don't,
bro? So they're seeking the death penalty, but they can't. He can't talk to his lawyers. What's going on for real? For real? Like, what's up?
No. The request for relief is directed at BSO for its refusal to allow the plaintiff his guaranteed access to counsel, relief that was denied by the state trial judge. Petitioner will establish the evidentiary hearing that he has been the target of clear violations of his constitutional rights. 6th, 8th, and 14th Amendments. When he brought these deprivations to the attention of a state trial judge, relief was refused. Because the ruling constitutes a non-final order in a criminal case, petitioner has no available avenue for an appeal under Rule 9.140.
Oh my god, bro. This man is cooked, bro. My nigga Melly cooked, dog. Ooh, that's gave me some chill, cuz. I'm aspiring a little bit. Yeah. Fuck, man. Rest in peace, Sakchaser Juvy, man.
Of the Florida Rules of Criminal Procedure that governs final orders. And since the constitutional violation does not arise from a ruling on pre-trial release, Florida courts have no jurisdiction to review the Florida trial court decision. Accordingly, because petitioner has no ability to have the denial of access to his counsel reviewed by a Florida appellate court, any requirement that he pursue unavailable administrative remedies would be futile. At the status hearing, the court directed petitioner's counsel to address response claim that the petitioner failed to exhaust available remedies in the state court. The relief petitioner is seeking, and specifically how the relief would not infringe on abstention principles, and whether the petition was timely filed. The short answers are as follows. Petitioner is facing the death penalty. Melly's asking the court to order the BSO BSO as the detaining authority to permit his chosen lawyers and investigators pursuant to his Sixth Amendment guarantee to visit him in jail and participate in meaningful evidence review and case preparation without having to circumvent artificial barriers that interfere with his constitutional entitlement. Number 2, permit Melly to telephone his attorneys when consultation for his case preparation is needed, just like every other inmate in custody. 3, remove him from what is tantamount to permanent solitary confinement. 4, permit him video and telephone contact with his family, including his mother, just like every other inmate in custody. 5, issue appropriate orders should BSO refuse to comply with the court's directives, including releasing petitioner from...
It's sick, bro. It's sick as fuck, man. It's sick, right? Because all they want to do is break bro now. They want to break him mentally first. Once they break you mentally in that box, now it's over with. Now they own you, bro. Now they finna, you feel me? Like, damn, bro. Damn, cuz Melly, like, what the fuck, man? I'm rooting for Melly, man.
Custody if necessary to protect his constitutional rights. So the 5th one is a Hail Mary to let him be free until the trial, pretty much. I
don't get it fucked up. You know, we still got the victims, you know what I'm saying? I still, excuse me, think about those too, but I don't want to see no nigga locked up or in that goddamn tomb. You know what I'm saying? That ain't it.
To figure something else out. They can't just have him talking to no lawyers or friends or family and not have any contact with any jail guards or other inmates at all. He can't talk to anyone. It's insane. Petition is timely. Constitutional violations are ongoing and severely impacting his rights. Petitioner satisfied any applicable exhaustion requirement. Not required to engage in futile acts of exhaustion because no meaningful state court remedies are available. He's not seeking review of a bail hearing or denial of release. He cannot appeal from a non-final order in criminal case. He asked the trial judge to order compliance with basic and fundamental rights afforded to him by the U.S. Constitution to no avail. Review of that ruling must now wait the entry of a final judgment, making any state court ruling effectively moot. Petitioner has done what he can.
This is crazy, bro. Like, he did it. He's doing everything he can, and he's not getting no assistance from the state. Nothing, bro. Nothing. If I read correctly, they saying that he exhausted his his appeals. So I don't think he had got any more appeals left. As far as when it comes to his rights right now, I don't know. This shit is fucked up. I ain't even know they could do some shit like this, but it's a system, dog. You know what I'm saying?
And to bring his deprivations to the attention of the state court, and no further relief is available to him. Any contention by BSO must further exhaust state court remedies as illusory and futile, since there are no other remedy to pursue. No choice to put to file habeas corpus. The BSO argument favoring exhaustion is flawed for 2 reasons. Contains an exhaustion of administrative remedies conditioned for inmates serving a sentence under the judgment of a state court. Petitioner is presumed innocent, is not in custody pursuant to any final judgment of a state court. Right, so he's saying, that's the big thing too. He's currently presumed innocent. I know a lot of people hate that and they get triggered by me saying that, but that's technically what he is. We're in the United States, is how it works. And he can't talk to his mama or his lawyers, and he's presumed innocent. Second, the cases cited by BSO arise from convicted inmates challenging their conditions of confinement. For instance, Thomas versus Crosby,
crazy,
I remember them
bro.
citing this case too, arose in connection with the convicted state
You gotta
court.
understand, this nigga been locked up for damn near. Let me put it up. How many days? How many days has YNW Melly been locked up? Let me see. Bro, the man, they said on Google, they said the man been in jail since, what? Bro, 5 years, bro. February 13th, 2019, that nigga went in. It's pre-pandemic, my nigga.
Murder defendant seeking federal post-conviction relief from his judgment and sentence.
Damn,
The 11th Circuit explained the convicted state court defendants cannot avoid the exhaustion of state court remedies requirement of 2254 by seeking relief pursuant to 2241. Since convicted defendants must always comply with the federal jurisdictional restrictions imposed by the Anti-Terrorism and Effective Death Penalty Act of 1996 that governs petitions brought under 28 U.S.C. 2254. The convicted petitioner's petition is subject to both 224 and 2254. But as apparent here, petitioner is not a state court convicted felon seeking to challenge his state court judgment. And this has not asked the court to disregard the requirements of 2254 since that status is not applicable to his petition. So it doesn't apply. What BSO is yapping about does not apply. It's different because he's not even convicted and he's not seeking that. In Santiago Lugo versus Warden, better explains the relationship between the exhaustion requirement. A convicted inmate's failure to exhaust administrative remedies is not a jurisdictional defect, such that a federal court has jurisdiction over a claim of disciplinary sanctions imposed without regard for due process requirements. The court explained that it no longer the law of this court circuit that exhaustion of administrative remedies is a jurisdictional requirement. Convicted defendants are still subject to administrative exhaustion requirements. Melly is not seeking relief from this court as a convicted defendant who has an ample opportunity to seek review of his conviction through an available state court appeal. Melly has not been convicted, is not challenging the legality of his incarceration as a result of a state court judgment, and has no available remedy to appeal from the trial court's order denying him relief. Yet his constitutional deprivations continue and will remain throughout his trial, likely exacerbating the possibility of his being oh, it's a typo, him being convicted without meaningful access to his counsel during his incarceration. Yeah, it's kind of fucked up if you think about it. Straight up, it's violating his right to a fair trial. He's not able to talk to his lawyers. What are we doing here? They can't look at shit together. There's a wall.
Like, what do they expect the brother to do? Like, you feel me? He's just fighting without attorneys at this point. I mean, he just let his attorneys just like, you know, wing it basically. Like, that's fucked up, man. That's fucked up. And really, bro, he should be able to, like, if he loses this case, he gotta be able to appeal this motherfucker, bro. Look at the games they playing
between them. The exhaustion requirement therefore is applicable only to those state court petitioners who are in custody pursuant to the judgment of state court, people who are convicted. Just as importantly, there are no administrative remedy available for petitioner to exhaust because the Florida Appellate Court has no jurisdiction to conduct a review of non-final order in a criminal case. The U.S. Supreme Court long ago counseled that federal courts must be cautious in declining to exercise jurisdiction to vindicate constitutional rights. We have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution, in bold and underlined right here. Holy shit. Nor can this court abstain from exercising jurisdiction and deference to a state court
I think he gonna get his case thrown out on a technicality. Can you say this shit right? Technicality, just due to the fact that they playing dirty ass games, bro. It's violating his rights. You feel me? Straight up. Like, I don't know what more or what. You feel me? Like, it's in broad day. It's in the paperwork, black and white. So I'm just like, bro, like, what is going on, bro? I hope this man get free for real, and he's able to speak to his attorneys and get the proper help he need, regardless if he guilty or not, bro. Don't matter. Everybody who, you know what I'm saying, get locked up deserves a fair trial. I don't give a fuck.
Judicial proceeding that is not available and whose eventual exercise of jurisdiction would moot this controversy by awaiting petitioner's conviction. In summary on this point, petitioner has done all he can do to obtain relief in the state court. This court cannot abdicate its jurisdictional responsibility to adjudicate serious constitutional violations. The court ruling was not appealable or reviewable as a matter of right, and a trial court's order in a criminal case are not ripe for review until the entry of a final judgment. The constitutional violations would continue through the outcome of the petitioner's death penalty trial and sentencing. Without any effective remedy to seek the state court review of the unconstitutional administrative conditions of the petitioner's incarceration, federal court relief through 2241 is the only available remedy to cure the unconstitutional conditions presented in this case. Neither exhaustion nor abstention. This court has and should exercise jurisdiction to consider and rule on petitioner's constitutional claim. The court should order BSO to afford the constitutional protections outlined herein. Failing that, this court should impose sanctions, including the initiation of injunctive relief to ensure the petitioner is able to exercise his fundamental constitutional rights while awaiting trial. Isn't that crazy? They're basically begging to give this guy a right to a fair trial. That's what's going on here. BSO is going to be able to respond to this, and there's a hearing set on February 19th. Hit subscribe to ensure membership. Love you guys. Peace out.
I don't know. Hey, man. That was a YNW Melly update. You feel me? I don't know what the fuck they got going on with Brother Broward, but he can't see his lawyer. He can't talk to his family. It's looking crazy for Buddy right now. I was about to say for my boy. Don't know the nigga at all. But he from Florida. Stand up, nigga. Guilt for Florida, nigga. Y'all stand up, nigga. RP Juvy, RP Sakchaser. I'm gone.